Hello, my name is Eric Niederlander, and I'm with Trusted Elder Law and Asset Protection, a Pensacola, Florida-based estate planning and elder law firm. I'm licensed to practice law in the state of Florida and Alabama and can serve clients all across both Florida and Alabama and locally in Pensacola, of course. Today, I want to talk about the difference between a living will and a will. A living will states that in a situation where it's an in life stage condition, or you have a terminal illness, that you say either you do or don't want to be kept alive by a machine like a ventilator, and you're appointing somebody to carry out your wishes in a healthcare surrogate, but the living will kind of outlines the details and the various situations on what you want to take place. Yes, you want to be kept alive by a ventilator. No, you don't want to be kept alive by a ventilator if it's an in life stage condition or a terminal illness. And of course, all this is in consultation with the doctors. But if you're unable to communicate your wishes, you've set this out ahead of time in the living will. Whereas a will directs who is to receive your assets at the time of your death. Do you want it to go to your family members? Do you want it to go to charity? Whatever you want done with your assets, and then you nominate in the will a personal representative, and that person is appointed to carry out your wishes, and they collect your assets, pay any creditors, and then pay out the remainder according to the terms of your will. So sometimes people come to the office and say, I want to avoid probate. I need a living will. Well, a living will doesn't avoid probate. A living will is, like I said, for determining your final wishes for healthcare situations. And a regular will does not avoid probate either. I talk about it in another video where the only way you avoid probate is to not die with assets solely titled in your name with no beneficiary named on the asset, or you create a revocable living trust and retitle all your accounts and property into the name of the revocable living trust. The will is kind of the ticket to probate. A will only has a life in existence in a probate, and it's the guide for the probate. So it doesn't avoid probate. But if you want to avoid probate, or you need a living will to state your final decisions on, do you want to be kept alive by a ventilator? Do you, in the various situations, then give me a call. Again, my name is Eric Niederlander. I'm an estate planning and elder law attorney based in Pensacola, Florida. I'm licensed to practice law in Florida and Alabama and can serve any resident of Florida or Alabama, regardless of where you're located. And I can be reached locally. The number is 850-607-2222. Or our toll-free number is 855-ELDER-FIRM. And I can be found on the web at trustedelderlaw.com. So if you have estate planning or elder law needs, give me a call. I look forward to hearing from you and seeing how we can help.